Welcome, Councilman Rosine, to committee. I don't want to keep you waiting because I know you have personnel right after this. So what I'd like to do is get started, and we'll start off with our report from our director from planning, because I know she has a really tight schedule as well. And that way we can proceed with the presentation. And once my colleagues get here, we can go through the agenda. But in order to expedite some time, we can ask our director to give a report. Welcome.
I will be very brief today. I wanted to let you know that we are conducting community plan workshops in Boyle Heights for our new community plan. We have scheduled 4 over the next few weeks, and the first will be this Saturday on the 31st at the Boyle Heights Senior Center. The planning department is spending a lot of our time right now on 2 citywide ordinances that you in the City Council have directed us to work on. One is the mixed income ordinance. We are having our second technical advisory committee meeting this Thursday morning. It is the second of what will be 3 or 4 meetings, and we're trying to stay on schedule to get back to Plum and the Housing Committee in February. The other citywide ordinance that we're spending a good deal of time on right now is the sign ordinance, and as you know, we're on a tight schedule. We went to the Planning Commission this last Thursday. They were unable to get through the entire discussion, so they are having a follow-up special meeting on February 19th, which will allow us to stay on our 3-month schedule to get back to you. So those are the things that we're working on primarily right now.
And those are very crucial issues, and I appreciate the attentiveness that your department and your leadership is demonstrating in dealing with these very complex issues. So thank you for that.
Thank you.
And I appreciate your brevity as well. Thank you. Okay, as my colleagues arrive, we have 4 items. 5, Councilman Weiss is here, and we'll just dig in. Just a few of the housekeeping points for you to consider. One is when you come up to the microphone, please give us your name and address. Also, keep an eye on the clock. You have 2 minutes. I think we can handle 2 minutes. Assuming, and I want to make sure that the public hearing cards and public hearing cards are closed now, Barbara, so that's all we'll take. You've got a few more in your hands, and it stops now. If anybody else wants to submit cards, we can put them on there for the record. But this will essentially close off a public hearing cards. And so please keep your eye on the clock. Many of you have written some very eloquent letters, and sometimes you don't get to your main point. So it's good to stay focused on the main point of your letter and your message. If someone has already stated what you wanted to say, it's okay to say, I agree with the person that just spoke or the people that have spoken previously, and add any new points you might have. Then that we would appreciate. That being said, we do have item number 4 on consent, and I don't see any cards. And are you okay with that, Councilmember? We'll move item number 4 on consent. Items 2 and 3 are related, so let's go with items 2 and 3 and invite Councilman Rosine to speak before this committee, because I know he has to rush on to his personnel committee that he chairs. So before you start, Councilman, we can have Roberto read into the record items 2 and 3, because it will move on both of them together.
Yes, Council Member. Item 2 is a report from the City Attorney. It's a draft ordinance relative to the medical marijuana issue, and also there's a comment letter from the City Clerk. Item 3 is an LAPD Commission report relative to the medical marijuana issue. And item B, as part of number 3, is a City Attorney report dated May 5th.
Okay. Councilman Rosine, welcome.
Thank you, Mr. Chair, Mr. Weiss, Mr. Weezer. This is regarding medicinal marijuana. In 2005, I introduced a motion regarding medicinal marijuana. My intention at that time was to establish regulations that would create safe, accessible environment for patients who under California law have been prescribed medicinal marijuana. Also, I wanted guidelines that would assist law enforcement, and we have law enforcement here this afternoon, to distinguish the difference between lawful collectives of patients and caregivers versus enterprise to distribute recreational marijuana. Unfortunately, the draft ordinance presented by the city attorney April and last night do not achieve the objectives. According to caregiver advocates, the vast majority of medical marijuana patients are members of collectives with storefront dispensaries. Unless the city ordinance addresses these facilities, we have essentially denied access to medicinal marijuana in our city. The Attorney General, in August of 2008, guidelines specifically state that the properly organized and operated collectives or cooperatives that dispense medicinal marijuana through a storefront may be lawful if they comply with the guidelines reference to business forms and operational structure. City Attorney's draft ordinance fails to address the regulations for cooperatives and collectives, which, according to the Attorney General, may, as a practical matter, have to organize as some form of business to carry out the lawful activities. The City Attorney cites the recent California Supreme Court case, Mensch, discussion as support for not including regulations for collectives. That decision appears to deal with the definition of caregiver and the fact that Roger Mensch sold marijuana to collectives of which he was not a member for profit. The decision does not seem to contradict California guidelines by the Attorney General, and my hope is that this committee will instruct the City Attorney to present an ordinance that provides regulations to properly organized collectives that operate under the guidelines explained by the Attorney General. We must give the residents of Los Angeles a reasonable ordinance that allows safe and practical access to medicinal marijuana and gives law enforcement the tools to shut down facilities that traffic drugs for recreational use. And we know that since the moratorium took place, a number of locations have opened, and basically nothing is being done. So unless this committee moves forward with something directing the city attorney to take action, we're going to continue on the same circle and accomplish nothing for the community and for those individuals who need medicinal marijuana.
Thank you,
Mr. Chair.
Councilmember, and you should be aware that the city family has been working on this process, this ordinance, and you will see through your notes or your reports from your staff the level of work that has occurred in the past 2 years. It's been a very delicate and very tough subject matter, and we're trying our best to put forth something that is implementable, enforceable, and fair. So
See,
I appreciate your patience.
The concern is if we don't establish something under the guidelines of the Attorney General, then we're going to be caught in the same situation where facilities are opening, recreational use or legitimate additional use, and there's no distinction. And basically at this time, it's a no man's land because no enforcement is taking place, and it's becoming a more serious problem than it was in 2005 when the motion was introduced.
I appreciate that, and I think we all share that sense of urgency.
Thank you.
We're all concerned for the welfare of the city, but again, we need to move diligently and judiciously, and that's what we intend to do today.
Thank you, Mr. Chair.
Thank you, sir. Okay, so let's begin with item number 2. We might as well continue down that path. We can ask the planning department to step up and give us the report. I understand they were leading the discussion group on this item. To have the planning department step forward as well as the city attorney.
Good afternoon, council members. Tom Rothman, the Planning Department. I'm just here to report back on the committee we assembled back in '07 for the medical marijuana dispensary group. We met for a series of 5 meetings. We held a group with members of the police department, stakeholders, planning department, building and safety, and interested council districts and other dispensary advocates. It was found out, it was interpreted over the course of those 5 meetings that the drafting of this ordinance would be more appropriate for the public welfare code as opposed to the land use code. So it was then, the ordinance drafting was relinquished over to the city attorney. And we haven't had any more drafting involvement. However, we have reviewed the ordinance, and we think that all the appropriate land use controls are incorporated into the proposal by the city attorney. There are parameters that we would have incorporated into any conditional use permit process, so we feel like this is really adequate for something that would be in the planning and zoning code also.
Thank you, sir. Okay, our city attorney, please.
Good afternoon. Heather
Good
Aubrey,
afternoon.
City Attorney's Office. What you have before you today is a revised draft ordinance establishing regulations related to medical marijuana collectives or collective cultivation of medical marijuana. To take a step back and look back at the law as it relates to this issue, back in 1996, the voters here in California passed an initiative entitled the Compassionate Use Act, which established the right of those who are deemed to be qualified patients, that is, someone for whom a doctor has recommended the use of marijuana to treat medical conditions, may, under law, possess and cultivate and ultimately use that marijuana for personal medical use, if in fact that person is a qualified patient, without being subject to criminal sanctions for those activities. Primary caregivers also are specified in the original Compassionate Use Act as individuals who may grow marijuana on behalf of a qualified patient whom they care for and have been designated as a primary caregiver for. And they too would be exempt from state criminal sanctions related to possession of the marijuana, obviously for provision to a qualified patient, and cultivation of that marijuana for the patient. Subsequent to that, we had in 2004 the Medical Marijuana Program Act, also known as SB 420. And that state law essentially expanded on and elaborated on the law with respect to medical marijuana, and specifically provided for instance, the Medical Marijuana Identification Card Program, and made other, again, clarifications essentially related to medical marijuana. Of particular note with respect to the ordinance before you today, it specifically allows that qualified patients and primary caregivers may associate to collectively cultivate medical marijuana. What is of particular note is nowhere in either the Compassionate Use Act nor in the subsequent state legislation, SB 420, are medical marijuana dispensaries provided for that sell marijuana. The reason that is of particular note with respect to the ordinance before you today is that there are several regulations established in this ordinance related to what is specifically allowed under state law, and that is collective cultivation. Should a location comply with the requirements set forth in this ordinance, they would not be subject to state criminal sanctions under state law or this ordinance related to their activities. Those activities are, again, collective cultivation, and for public safety reasons, there are various regulations related to ensuring the safety of the public related to that activity. Sale of marijuana is one of the regulations specified that is not allowed, and that is consistent with state law. To the extent that medical marijuana dispensaries engage in the sale of marijuana, they are not in conformity with state law. And to jump ahead directly to that issue, there is abundant case law regarding that issue. Most recently, People v. Mensch, which though it did not directly address dispensaries, it made it very clear, and this is the state Supreme Court, that the definition of a primary caregiver does not extend to someone who merely provides it. There has to be a very specific relationship in place that would enable someone to claim the primary caregiver defense. Clearly, state law has established that dispensaries do not fall within this definition. We believe that our position, the ordinance you have before you today, is in conformity with state law. It enacts reasonable regulations that ensure the safety of the public, and I'm here to answer any questions you may have regarding that.
Thank you very much. And what I'd like to do is hear from every department that would like to put forth their observations and our comments for the record today. Then we'll open up to public comment, and then we'll come back to questions.
Thank you.
Thank you very much. Any other department like to step up? Come on up, give us your name and department you're with.
Good afternoon. I'm Holly Walcott with the Office of the City Clerk. The ordinance that is before you talks about registration with the Office of the City Clerk, and the concerns, and you also have this in writing in front of you, and it remains even with the revised version of the ordinance, is that the registration takes place at the Office of the City Clerk. The issue we have with that is that the registration requires that the City Clerk, as part of the application review process, determines that those that are registering meet the requirements of this article. So that puts the City Clerk, first, number one, in an enforcement role that we do not feel comfortable with. Second, this type of activity is not something that the City Clerk does in general. We do not take any other type of certificate or registration. So it's outside of our scope of activity. And further, we don't have the staff or resources to handle this activity.
Are there any departments that you're aware of that has that capacity in performing that type of function?
As far as registration, I'm probably not the expert. Any other permitting department, so I don't want to throw any other department under the bus. But any department that would have a permit operation, such as the police department, building and safety, or Department of Finance would also issue some type of registration.
Okay, thank you. And maybe I shouldn't have asked you that question, but we need to know who functionally has the capacity to perform, so I appreciate that answer. Yes, sir, Chief.
Council members, Charlie Beck, I'm the Chief of Detectives for Los Angeles Police Department. I've spoken directly to Chief Bratton on this issue. We've met with the City Attorney. We endorse the City Attorney's legislation on this matter. I want to be very clear that the Police Department, Chief Bratton, myself, our Narcotics Division, support the medical use of marijuana as provided by state law. What we do not support is the commercialization of these ventures. There are over 400 current storefronts in the city of Los Angeles. In their unregulated state, they are the hub of crime. We've had several homicides occur, a lot of nighttime break-ins and robberies, a lot of money involved, and that's the issue. The issue is the money.
So it's the commercialization element of this.
Absolutely, it's
process.
the use of of what is a compassionate act by not only by definition but by nature for commercial purposes, and that is the issue, and that is what has caused crimes to occur in all of your neighborhoods. That is what has caused blight and also contributes to disorder.
If access was allowed through pharmacies or through hospitals or through clinics that are medically recognized, would that fall under your concern with commercialization?
And this is not something that I have discussed with the city attorney, but it sounds to me like what you're talking about is the legitimization of marijuana as a drug controlled by health and safety codes and through pharmacies and through that type of thing. And on the face of it, without having further discussion on that, it would appear to me that would be a legitimate way to control this. Now, I think that the collaboratives are an outreach of that, an extension of that. And if they are managed correctly and they are true collaboratives without financial gain involved in it, then I think that is something that we can regulate. In the current state, where there is so much for profit and there is so much money involved, I tell you that it is nothing but problems for the city and for your individual districts.
Well, Chief Beck, I've always respected the work that you've done in the city and indeed in my district. We will have public comment. I'm not sure if your schedule allows for you to stay or have someone designated here in case we have
Sure.
more questions regarding the LAPD's role in this process.
Well, we think this is very important, and I'll be here, as will Commander Gannon and Captain McCarthy from Narcotics, so we'll be available for this committee.
Thank you, sir. Any questions for the chief, my colleagues? No? Okay, thank you. Thank you, sir. Building and safety, this is a moment that you have to step up if you'd like, because I want to make sure you were included. We're not being exclusive. I have a question for building and safety. Well, building and safety coming up. You have a question anyway.
I have a question for building and safety. Earlier, the city clerk or a representative from the city clerk's office suggested that they are not the appropriate department to take in and issue the certificates. When I think of whether people are complying or not complying with a use of property, I think of building and safety. Would this be more appropriately housed in the building and safety department? Some of those responsibilities that were given to the city clerk, that is.
Okay, I'm Frank Bush. I'm the Assistant Chief of the Code Enforcement Bureau. Actually, building and safety will be involved to help enforce on the building code and the zoning code issues in here. We have limited abilities to work within this. The marijuana issues and things we, won't be dealing with. But we issue building permits, zoning, electrical permits, plumbing permits, things like that. We don't really do registration, take care of registering, people or businesses like that.
So any other type of, you don't do this type, the registration and
Right.
the type of issues that are given to the city clerk's office?
Right.
Okay, thanks.
Okay.
Okay. Thank you.
Anything else to add, given that you participated in this group discussion for the past how many years? 2 years? Nothing? Well, let me ask you, what is your reaction to the ordinance as drafted?
If you ask me as good afternoon, this is Hector Buitrago, Department of Building and Safety. If you ask me as a building official, that's how we're going to look at it. We're just going to look for code compliance. So we look at the amount of lighting, we look at the bars on the windows, and that's all really that we can look at. As far as zoning, this use is an agricultural use. So wherever you can have a vegetable garden, you can grow marijuana. And somebody's going to keep track of this 1,000 foot distance between establishments as well as between the child care places. That's about all that we can do.
Okay, thank you.
Welcome.
Okay. Any other departments that have been involved in this discussion? Okay. Let's hear from public comment, and then we'll go back to questions. I'd like to ask Lisa Sawayo. I apologize, I butchered the last name. Sawayo?
Hi there. My name is Lisa Sawoya. I'm a medical marijuana patient, medical marijuana activist, and a former collective owner. I have been I'm an original member of the Medical Marijuana Working Group that convened in the spring of 2007, and I participated at every single one of those meetings with my colleagues. I have to say that after reviewing the ordinance and the ordinance that was given to us at 2 a.m. last night, that it is quite obvious that I have to say I'm very disheartened. I am disappointed because the city attorney really did not take into account any of the activists' comments, suggestions, the people that are in this business as patients and as business owners. There are several aspects to this ordinance that do not make sense. Edibles, concentrates, really this ordinance is filled with prejudice, it's filled with ignorance, it is filled with a true lack of sensibility. I have to stand before this committee, again, very disappointed because it's been almost 2 years, okay? And what has happened? When you put a moratorium in place, you had 183 dispensaries register. Just like the gentleman from law enforcement said a few people ago that there are over 400 clubs now. The moratorium was obviously political posturing, it was a stall tactic, and it has done absolutely nothing to prevent the implosion of the medical marijuana collectives throughout this city. I am asking you, what are you waiting for? please make this a priority. This problem is not going away. It is only growing, and we would appreciate it if you do the right thing. Thank you.
Thank you. Now, ma'am, before you walk away, given that you just stated you received the ordinance at 2 a.m., and I understand the brevity of how much overview you've had, will you be in a position to have a written comments in reaction to the ordinance?
The group would love to have written comments. Is that we find it very frustrating that when the city attorney took this on, that the working group was disbanded. We were told that we no longer were needed. And again, our comments, I spent my time as well as my colleagues participating in this process to bring this city. This is the largest city in the state. Okay, I don't understand why it is taking so long to deal with this issue.
Okay, I just want to make sure it was understood that I am looking for written comments. So I appreciate your response.
Absolutely,
Thank you.
Thank you.
Thank you. Next is Yami Bolanos.
Hello. My name is Yamilet Bolaños. I'm a registered voter that resides in the city of Los Angeles. I'm a patient operator of a collective, and I'm also part of the Greater Los Angeles Caregivers Alliance, which is an organization that was formed to let the collectives in the city run at a higher standard, okay? We have really strict operational rules. I'm also part of the working group. I've been coming to all the meetings for the last 2 years, and I too am greatly disappointed in what the city attorney put out. It does not address the collectives in any way, shape, or form. I don't understand. I'm sorry, this is a very emotional subject for me because I am a true patient. I am a liver transplant survivor. I'm a cancer survivor. And I know how much the medicine is needed and used in the city for patients. And I am very offended by the ordinance because it does not address us in any way, shape, or form. And so I feel the last 2 years that I've been coming to the working group and that I've been participating and giving ideas was a waste of my time. It was a waste of all of my colleagues' time. The city attorney did not address us in any way, shape, or form that is productive in any way. And I'm very disappointed, and I'm here to tell you guys, and that's it. I'm very disappointed. It's totally unacceptable. It does not address us. It does not take into, it just does not address us in any way, shape, or form. I'm really sorry that I'm so emotional about this, but it just angered me that they waited to 2 o'clock in the morning to put this out. So we had our comments directed to the last piece of crap that was written. But the one they gave us today was even worse. And I'm very angry about it, and I'm just here to tell you guys that you guys need to focus on what the needs of the storefronts are in the city. And this piece of crap does not address it. So I'm very sorry, and thank you.
Okay, Jennifer Lyons Farrell.
My name is Jennifer Lyons Farrell. Good afternoon. I am a medical marijuana patient. I'm a medical marijuana provider. I too, well, first I would like to say I agree with everyone that has stood in front of me today. They have made comments that have both been heartfelt and well-educated. The ordinance that you guys received last night, or that we were privy to last night at 2 a.m., or this morning at 2 a.m., does not address anything that Councilmember Zine requested. It is not, it basically looks to us as a way to shut down any of the medical marijuana collectives within the city that were willing to work with you. You set out a moratorium, what was it, 2 years ago? 183 registered. 183 were willing to work with you. 183 were willing to stand up to the plate and say, okay, great, my city's ready to regulate, give me some guidelines to work within. We were willing to provide you with information we did not want to provide with anybody else. As the officer said, there are now over 400 clinics. The clinics that have opened up since then have either not been issued licenses, are opening up in a renegade, and they are abusing the system. I'm not here to help. I'm not here as an advocate for those that are abusing the system. I am here to advocate for those who want to work within the system and work within the council's guidelines. Many people stepped up to the plate and worked within that working group, and it was completely ignored. And it's very disheartening to see that the people that I elected to put in office are ignoring me as a voter.
Thank you. Don Duncan?
Good afternoon, Mr. Chairman, committee members. My name is Don Duncan. I'm a resident of Los Angeles and the California Director for Americans for Safe Access, the nation's largest medical cannabis advocacy organization. Yesterday, I sent you a very long email talking about the city attorney's response to Councilmember Zion's inquiries regarding this ordinance, and I hope that you will have an opportunity to review that. And I would also hope that that would become a part of the record of the proceedings of this hearing. It's very important that the city adopt regulations for medical cannabis collectives, and I understand that the clock is ticking. But it's also important that we do it right. And the city attorney's ordinance from April missed the mark, and last night's ordinance misses it by an even wider margin. In Los Angeles, there are storefront facilities maintained by legal medical cannabis collectives and cooperatives that are in need of regulation. Pretending that they're not there or falling back on an old opinion that they might be illegal is simply not acceptable. The California Attorney General has clarified that under SB 420, collectives and cooperatives that are properly organized and operated can maintain storefront facilities to provide medicine. The Minch decision cited in the city attorney's report doesn't deal with this issue. It deals with individual caregivers. And this continual confusion about what is a primary caregiver or a collective is troubling because we spent some time in the working group dealing with that very issue. Storefront facilities maintained by legal collectives and cooperatives are not primary caregivers. They are not the issue addressed under Minch. These are facilities that are specifically authorized under the state law, so long as they are truly collectives and cooperatives made of patients. And so I would like to ask you today to reject the ordinance, send it back to the drawing table, and let's write one that deals with the request of Councilmember Zine and what the city needs, regulations for the existing storefront collectives in Los Angeles. Thank you.
Thank you. Michael Levitt?
Good afternoon, council members. I'm Michael Levitt from 21014 Cantara Street, Canoga Park, California. I stand before you as a medical marijuana patient that is battling a life-threatening illness right now. And I want you to know that medical marijuana is giving me a wellness campaign and routine to keep me going and to keep me fighting my disease. I've read what you guys are proposing to do to the medical cannabis community at large by eliminating basically a safe access way for me to get medicine. What you're going to do, if you keep on with this proposed ordinance that you've got right now, is you're going to drive the price up of cannabis past what I'm going to be able to pay. It's already bad enough that I'm barely able to make my monthly payments for Kaiser, but you're going to make it impossible for me to have this because you're going to make such a narrow margin of people that are going to be able to supply medical cannabis to the community. Now, I stood forth and I listened to the police come up here and say, gee, we can't protect these collectives because there's a lot of money in them and things like that. Well, the bottom line is what am I paying for police for? The bottom line is if I were a jewelry store or a bank or a place that carried high-end anything, is he not going to be able to protect my establishment too? So coming up and saying that the community has to be such a small sliver of an area to operate, you've got a route that's on there, some sort of safe access route for, I guess, students to go by. You've got a 1,000-foot regulation there where collectives could be. The bottom line is, in this condensed city, what you're doing is you're just screening us out completely, so there will be no safe access. I'm asking you to reject this ordinance and sit down with patients in the community that are battling life-threatening illnesses that are utilizing the medical cannabis. Sit down with us and give us an option to work together to get something that we can do that's going to be viable. Thank you.
Thank you, Mr. Levitt. James Shaw.
Forgive me, I'm a little under the weather today, but I got myself up because I got an email this morning saying this crisis, come on down, see what's going on. My name is James Shaw, and
I need you to speak into the mic so we can get you on the record.
I will.
Okay.
My name is James Shaw, and I represent the Union of Medical Marijuana Patients. And And I'm down here today to first and foremost say that, and by the way, good afternoon, Mr. Chairman and Councilman. Thank you for being here today. I appreciate your willingness to hear from the public. First of all, I'd like to say that the substantive issues raised in the City Attorney's release just last night of this revised ordinance brings into question the ability for the public to respond. And I'm listening to some of my distinguished colleagues speak today, and I'm even looking at my own ability to put together a response, and I'm realizing that we're taxed by the short notice. And so I would request that this hearing be rescheduled so the public actually has a proper amount of time. I believe 72 hours is the standard for such situations. But I did want to take a moment to address some of the issues that have been spoken here today. First of all, I'd like to agree with the city attorney that if everyone followed the guidelines, that no one would be subject to state sanctions, or they probably wouldn't be. One of the challenges is that most of the, and if I may back up a moment, the Union of Medical Marijuana Patients is the organization that's currently suing the DEA for extortion for their efforts with the landlord letters to evict tenants via the landlords, extorting them with forfeiture, threats of forfeiture, and imprisonment, which is nothing the U.S. Attorney has ever hinted at. The city attorney is correct in saying that the establishments wouldn't face state sanctions, and primarily because they'd have to practically go out of business. There's a number of issues. May I continue?
I need you to conclude.
Okay. That will be hard to do in a second or two, but the ordinance as it's handed down is a recipe for disaster for medical marijuana collectives. SB 420 established, our legislators established that we should be able to operate as collectives, and the ordinance as it's designed would effectually push everyone underground or have them shut down. And I have a whole lot more that I could say, but hopefully we'll have another hearing when I can address those issues. And I'm sorry we missed you at the celebration last Tuesday. It was quite amazing. Potential hopeful Paul Koretz was out speaking on behalf of medical marijuana patients, and I hope that you all will continue to work on behalf of medical marijuana patients.
Thank you, sir. Elizabeth Fuller? Elizabeth Fuller? Good afternoon.
Hi. My name is Elizabeth Fuller. I live at 903 South Sycamore Avenue in Los Angeles. There are 3 marijuana dispensaries within a 2-block radius of my house. On October 1st of 2008, there was a robbery and murder at the dispensary at 812 South La Brea. It happened at 3 o'clock in the afternoon when the streets in the neighborhood were full of kids walking home from John Burroughs Middle School, and when Wilshire Crest Elementary School, which is right across the street from my house, was full of kids in its after-school program. The Wilshire Crest was put on lockdown for 3 hours, during which parents tried to get to their kids to take them home and couldn't. There were police escorting children home to their doors because the whole neighborhood was on lockdown because one of the gunmen escaped and wasn't caught that day. A week after the incident, the gun from the guy who got away was found stashed on a porch in our neighborhood in a house where a 6-year-old lives. The situation currently is not safe. I am all in favor of safe, legal medical marijuana, but a key word there is safe. And the current situation is not safe, and I urge some action on this rather than keeping it tabled again and again and again. And I understand that it's a touchy issue and that there are dispensaries willing to work with you, but I think we need to get the process moving. Thank you.
Thank you very much. Daryl Hunter?
Hi, guys. I'm with the Eagle Rock Neighborhood Council, the Public Safety Commission. We've put together, we sent a community impact statement with this ordinance that should be there. I don't know if you want copies of that. And again, November 11th of 2008, we approved the impact statement.
I have copies.
Oh, okay. Basically, we looked at the ordinance. We feel it could go a little bit further. We suggest We like the idea of building and safety and the LAPD perhaps having some sort of interagency commission to oversee it. That seems to make sense to us. As well as the ordinance doesn't seem to address restrictions on density. It talks about every 1,000 feet. It doesn't really talk about how many. We have, at least right now, as of now, 11 within a 3-mile radius, and it seems to be a lot. And finally, in the ordinance, there's no restriction on for-profit dispensaries, which the state guidelines put up by the Attorney General addresses, and that's not in the ordinance. So our community impact statement, I think, speaks to it more eloquently than I can, but those are just some of the issues we have, and we just wanted to bring it to your attention. Thank you.
Thank you, sir. Matthew Abrams.
Hello, my name is Matthew Abrams. I'm a patient and operator of a medical marijuana collective. The ordinance as written looks completely ineffective to me. We have problems with arbitrary language in there. It looks like it doesn't discuss what a collective is or what true patients are. As mentioned by my distinguished colleagues here, it's ineffective, and there's 400 now. And with this type of having to go back and revising and after revision, more are going to pop up. And actually, I think as the market gets bigger, the market actually regulates itself. So the price why my friend here was talking about not being able to afford medical marijuana, that this ordinance as is will limit the amount of dispensaries, providing for a monopolization effect of areas by being able to raise prices and essentially have neighborhoods that you own. And that's what it looks like right here by this 1,000 feet and this anti-cluster rule. It looks completely ineffective to me. And I just want to say that I would like an ordinance that discuss cultivation, collectives, and the actual amount you're allowed to carry, because this 5 pounds is completely arbitrary to me. Thank you.
Thank you, sir. The next speaker is spelled D-E-G-E. I don't want to mispronounce it. Canty.
Good afternoon, council members. My name is Dejay Kuti.
Dejay Kuti.
I reside in the city's 4th district. I also served on our city's medical cannabis working group, and I also urge you to please reject the city attorney's new draft of this ordinance. It still does not address Councilmember Zine's concerns. It's completely out of step with the Attorney General's guidelines, which requires dispensaries to be non-for-profit entities, which would alleviate some of the things that we're hearing from the police and from the city attorneys, because our dispensaries are supposed to be nonprofits. It sounds to me that the city attorney has kind of picked and choosed what was convenient for their position on this issue, and what they have created is clearly unsafe for patients. The working group must reconvene to finish the important details we were working on when we were disbanded by the city attorney's office in October of 2007. At that time, we were on target to present you with a very good working draft by January of 2008. I'd like to ask you to please, let's start drafting good dispensary regulations immediately. Let's hear the hardship requests so patients can know again who is in compliance, and let's enforce the ICO so those who might want to harm our community are not allowed to do so. Thank you.
Thank you, Ms. Brown. Elliot Katz. And then we'll have Brett Stone.
Good afternoon. My name is Elliot Katz. I live downtown here, and I am representing Arts District Patients Collective, Arts District Healing Center, which is a collective located very close by here. We're down the street. We are a collective. We're not for profit. We give away medicine to so many people who cannot afford it. I did not participate in the working group like my colleagues because I knew how it was going to turn out for them, you know. So we spent a lot of time coming to City Hall before, you know, when the ICO was being discussed and stuff. First of all, let me say this. It almost brings tears to my eyes that here I am at 46 years old and I can come to City Hall and speak to lawmakers about the future of medical marijuana. And I appreciate that more than anything, more than any of the negativity that's coming out of us. I read this ordinance this morning when I got in to the center and started highlighting 3/4 of it going, you've got to be kidding, you've got to be kidding. Come on. I mean, I have AIDS. I was diagnosed in '85. I'd be dead if it wasn't for medical marijuana. And I'm one of millions of people who can come up here and give you the same testimony. We need to be taken seriously. I feel like we're being treated like we're 15-year-old stoners trying to find a way to, smoke marijuana. It ain't about that anymore. It just isn't. We need to be respected, and we need to be listened to, and our participation, we need to see an outcome of that. We want to be able to see that we were participating in something. Thank you.
Thank you, sir. That was Elliot Cuthbert Stone. And then we'll have Richard Kearns.
Good morning, committee. Good morning, Commissioner. Good afternoon, actually. I agree with most of what my other fellow advocates have said, but what I'm here, Mr. Chairman, is you asked about the time period for comments. Just became of this revised ordinance overnight. I heard this morning from Aaron Houston of the Marijuana Policy Project in Washington, D.C. He's the only national lobbyist in Congress. He wants to run the ordinance past John Conyers and other members of Congress. There was no way to get a comment here today. I heard the same thing from Alan St. Pierre, the National Director of the National Organization of Reform of Marijuana Laws, the same thing from Dale Geringer, the coordinator of California NORML. I heard it from the attorney for Reason.org, David Knott. What they're asking for is a continuance of 21 to 42 days. They need time to digest this ordinance and submit the comments that you're asking for. On your agenda, it clearly states that if you challenge this committee action in court, you may be limited to raising only those issues that you or someone else raised at the public hearing described in this notice. We need fair notice in order to be able to put our comments together. I appreciate you wanting to move forward with the ordinance. We need an ordinance. Everyone is in agreement with that. But please continue this hearing so that we can put cogent notices and we need fair. I mean, this is just not fair. I know of doctors and attorneys that would like to be here, and they just heard about this hearing when they got up this morning. Thank you.
Thank you, sir. We have Richard Kearns, and our last speaker will be Lenny Fisher. And that'll close public comment.
Good afternoon. My name is Richard Kearns. I talked to the City Council this morning about the death of Martin Delaney, AIDS activist of Project Inform. One of the things that kept the AIDS community going is that we realized we need to change the rules. We understand that. Medical cannabis helps us survive the medicine. We understand that. But all of a sudden, we have a poison pill. This is bad faith. I'm extremely disappointed. It points up the need for a permanent medical cannabis advisory board that can stay on target with this process and help revise it, help build it. We're not doing pink berries here. We're building a village. We're building a city. We're rebuilding infrastructure. Okay, there's a lot that's important here, but the most important part is saving lives to make contributions to our community. All right? Just having a cause to get up here and stand up here is keeping me alive. So it's metaphoric medicine as well as physical medicine. We need the clinics, whether or not cannabis becomes legal. We need the medicine part of it. We need the expert advice. We need the meeting place for people with terrible diseases to come and experience some mutual benefit. This isn't Radio Shack, okay? We need to start again. We need to convene a permanent advisory board, please. Thank you very much.
Thank you, sir. Lenny Fisher.
Good afternoon. I'm Lenny Fisher, 44-year resident of the city of Los Angeles, medical marijuana patient and provider and activist. I don't know if you folks noticed or not, but the Attorney General mentioned Prop 215, SB 420. Didn't hear much of the city attorney's office about the Attorney General's report and recommendations. I don't see in this ordinance that they've given us that they've even taken that into heart, let alone the hard work of my colleagues. I suggest we put in the spirit of our new America with our new president, that we put our ideological differences aside on this issue, and that we really get into what's at heart here. Sick people. People that are dying. People that are hurting. People that deserve relief no different than you do from penicillin, Vicodin, or whatever else choice drug you put in your system. If we were to go with this draft ordinance that the city attorney's office brought to us, 183 clubs would have to close. Those are the clubs that stood up and put their necks out. And guess what? We all got DEA letters after that. The ones that sat here at the table working with you would have to close. While those other clubs that didn't register, that didn't follow, and that didn't try to do things legally and in the spirit of good faith, remain open. I'm asking you today, in the spirit of good faith, to reject 100% unequivocally this ordinance given to us by the city attorney's office and order them to go back and do it again and take into heart those folks that sat for hours of their own time unpaid working on an ordinance. I also ask that you take into heart the County of Los Angeles ordinance and kind of use that as a stepping stone of how to get this done. And please, let's not have any more delays. It seems to me that all this has just been is a big old delay tactic by people that don't believe in this. They think that we're just a bunch of stoners trying to get high, and that's not what it's all about. Thank you very much for your time.
Thank you, Mr. Fisher. I wanted to acknowledge the Executive Director for the LA Police Department's Board of Police Commissioners, Richard M. Tifak, and I want to thank you for being here, sir. If you don't mind just coming to the podium. First, I want to acknowledge all the speakers for their heartfelt and very straightforward and blunt reaction to the process. I think it's important if we're going to get to a place where we can work together and put together an approach that's going to work. But Mr. Tifak, the notion of a process in which we could create the registration and how you monitor, in your experience, are there any other departments that you feel have the capacity or the capability of working with the police department so that we are dealing with public safety, but also making sure there's access to the medicine? Is there a department that comes to your mind or you feel in your experience in working with the city family?
Good afternoon, sir, and Mr. Huizar also. I would just say from the Commission's perspective, as you know, Commission Investigation Division issues and monitors approximately 53 different type of police permits, everything from First Amendment type permits to pawn shops to other types of permits that we do the background investigation, issue the permit, and we also do the enforcement piece of those permits. I have not been a part of this process, however, from a permitting scheme process, the process that we utilize in issuing permits is one that we get an application. Depending on the nature of the permit, there would be a limited background investigation, which would be the individual submitting a Cal ID of their fingerprints to ensure that they have no violations which under the city code would prevent them from doing the type of business that they want to have a permit to do. And then various other processes to ensure that if they're going to be operating in a building, that the building has the appropriate zoning and appropriate building and safety checks, and that they're authorized to operate that type of business in the building they choose to do it in. Once all of those things are completed, we then issue a permit for that particular business to operate. So we're very familiar with backgrounding and permitting, et cetera. I don't know of any other department in the city that does what we do as far as a backgrounding process and that type of a permitting process. In this situation, as to the clinics that are before the body today, we would certainly be in a position to assist in demonstrating our permitting scheme in that process. And if the council so chose to give that process to the Commission Investigation Division of the Board of Police Commissioners, we could probably do the permitting process. As far as the enforcement piece, I do not believe that we have the staffing to do the enforcement piece of any violations of any of the permitting requirements that would be there. So that's what I would offer to begin the conversation, sir.
Now, in the working group, have you or your staff been able to participate in the working group in these past 2 years? Planning department cited 4 to 5 meetings. Has your unit been able to engage?
No, sir. We've not been a part of any working group meetings at all. From the police commission perspective, the LAPD has, but not from the commission or commission investigation division.
Okay, thank you. Thank you. Any questions, sir?
Right now.
Okay, thank you.
Thank you, sir.
Okay, I paused to do this, but I'd like to ask the city attorney to come up to the microphone, if we may, and in terms of the working group and what was being listened to as it evolved, and I think they mentioned sometime in October it was disbanded and we started working on the ordinance. The level of input by the working group into the ordinance, can you just speak to that so that at least this committee can understand how that was put together and what was the thought process by either including or excluding information that was being put forth in the working group?
Yes, the city attorney's office was one of the participatory members of the working group. There was input received from all of those around the table, literally around the table, including those who represented marijuana patient advocate groups and dispensaries. And so I can confirm that. With respect to the ending of the working group process, after approximately 6 or 7 months, the input that was received was certainly noted and considered. Ultimately, it's the law which determines the propriety of an ordinance put before you. And that ultimately is what was our main consideration.
I see. And looking at the reference to the Mensch case law, can you elaborate on that case law and how it's being put forth in this ordinance?
Certainly. It is correct that the People v. Mensch decision did not directly address dispensaries. It did clarify the definition of a primary caregiver and made it absolutely, abundantly clear that that definition is restrictive rather than broad. The significance of that with respect to dispensaries is that to the extent that many dispensaries have claimed and continue to claim that they are essentially serving as a primary caregiver, that is clearly not in conformity with the law, as stated by the Supreme Court in Mensch and in the many cases which preceded Mensch, including Lundgren v. Perrone, which did directly address dispensaries or locations that dispense medical marijuana, and specifically finding that they are not entitled to protection as primary caregivers under state law. Okay. And with respect also to the Mensch decision, I would like to point out there's language in that decision which I believe is directly relevant to the issue of dispensaries. Insofar as dispensary locations as they currently exist, it appears, do not in fact engage in the activity which is specifically allowed under state law, and that is cultivation as opposed to selling or simply distributing it. There's language in Mensch which states that the primary caregiver, Mensch himself would not, the primary caregiver defense would not protect him from prosecution for cultivating marijuana and providing it to cannabis clubs, which is another name for dispensaries. The significance of that is that it appears that the vast majority, if not all of these dispensaries or cannabis clubs, in fact, do receive the marijuana from off-site. They are not actually engaging in the cultivation on-site, which is the one activity that is specifically specified in state law in terms of being permitted as a way to provide access. So just so we're clear, this draft ordinance does not cut off access to medical marijuana. It allows for it in a manner consistent with state law, which specifically allows for collective cultivation. And specifically, the language of Health and Safety Code Section 11362.775 provides that medical marijuana may be cultivated collectively by, quote, qualified patients, persons with valid identification cards, and those would be people who also are qualified patients, and the designated primary caregivers of qualified patients and persons with identification cards, end quote. These persons may associate within the state of California in order collectively or cooperatively to cultivate marijuana for medical purposes and shall not, solely on the basis of that fact, be subject to state criminal sanctions under various Health and Safety Code narcotics violations. So it is that act of collectively cultivating which is allowed under state law or exempts those individuals from prosecution under state law, and likewise under this ordinance exempts those who engage in that activity from prosecution under the ordinance or state law.
So the bottom line is that the ordinance prohibits storefront collectives and cooperatives? I mean, that's the question.
Well, it's the activity engaged in those locations. It's not so much a storefront per se is prohibited under this ordinance. There's no language.
It's the nature of the transaction.
Exactly. It's the nature of the provision of the marijuana. It's specifically allowed for under state law that a primary caregiver may grow it for the patient that he or she is caring for and may, of course, then provide it to that patient. And the expansion of that concept in SB 420, the Medical Marijuana Program Act, is to allow the collective activity to take place so that if an individual qualified patient or his or her primary caregiver, for whatever reason, cannot individually do so, this allows for an association of individuals to do so and ultimately provide it to the qualified patients who are authorized to use it under state law. So thereby access is provided under state law.
And I'd like to ask Chief Beck, if you don't mind, sir, coming to the podium, and please stay there, Madam Attorney, because my intention, and if my colleagues agree, is to come back in 30 days. Believe me, I don't want to prolong this any more than anyone else does. We all feel the pain at many different levels throughout the city. And so I do want to get to a place where we can allow access, and still be able to take care of the quality of life for our citizens in our city. But Chief, what you just heard in terms of the nature of these facilities, one is we are not supposed to allow for the payment or the commercialization of the marijuana, but we can allow for the cultivation for the purposes of medical use. How does that affect, from your point of view, from a public safety? I mean, what challenges do you see given what the ordinance is allowing?
Well, in my opinion, and based on my experience, it is the transaction that causes the issue for law enforcement and for the community.
The transaction.
It is the sale for profit of the product, and that is what brings in not only people that use the provisions of this act as a sham in order to engage in recreational use of marijuana, but it also is the act that causes the large quantities of cash, the attractive nature of which creates robbery, burglary, and in a couple of cases this year homicide, as one of your speakers talked about earlier. So, as I said, the police department, Chief Bratton, me, nobody thinks that the medical use of marijuana is wrong if it is done as per the Compassionate Use Act. It is the issue that the city attorney so well speaks of, the commercialization, the selling of the product that is our issue, and having locations that are specific to the distribution of marijuana via the collective is something that I think that we can regulate if we have the direction from council and the advice of the city attorney to do so. So I'm not worried that we can't enforce a law that you make. What we're looking for is direction, and the sooner the better.
Okay. So it sounds to me like the win-win would be that we put together an ordinance that allows for the collectives to cultivate, to distribute for medical purposes, but to have them monitored to the point where we know they're not there for commercialization.
Yes, and with particular emphasis, as the city attorney spoke, of the prohibition of the sales of the product. That's what causes the evil in this, in my opinion.
Okay. Council colleagues, any questions for our staff?
Yeah, following up on this item, so as the ordinance is written now, we don't have a distinction between a collective that I assume is nonprofit and the commercial storefront dispensaries. Is that correct?
It's correct that a distinction is not specifically made. What the ordinance addresses is the collective cultivation, which is not a commercial activity. In fact, one of the regulations specifically states that there shall be no sale of marijuana or edible product containing marijuana. And regarding the commercialization issue, I would just like to make two additional brief points. One is that the very ballot initiative, the Compassionate Use Act, which established the right of seriously ill patients to use medical marijuana, in the ballot material supporting that, as quoted in Mensch, specifically states that the act was not intended to protect anyone who grows too much or tries to sell it. And that is quoted in Mensch, the People v. Mensch decision. So not only is it contemplated that they be nonprofit, but that they not in fact engage in sale. So I think that is a point worth raising.
Yeah.
And well, first let me state as well that for myself personally, I support the intent of Proposition 215 and the use of medical marijuana for those individuals who need it. However, in certain parts of my district, I've gotten contacted by a number of individuals, residents who are concerned as to the number of dispensaries that have gone up. They're concerned that they have gone up near schools, near places of worship, near parks, near areas where children congregate. But I think the overarching issue amongst all of these is that there has been an overconcentration of these dispensaries in any one neighborhood. Whether it's a dispensary for medical marijuana or anything else, when we speak about land use issues, the overconcentration of anything is not good, sound public policy. Does this ordinance at all address the issue of overconcentration of these facilities in a particular area?
The issue with respect to the location is addressed in regards to proximity to certain primarily child care related facilities within 1,000 feet. Beyond that, this is not a zoning or a land use type ordinance.
Okay, so it does not address that. Okay.
That is correct.
It could, though.
It could, but it does not currently address that. Okay. Also, a neighborhood council in my district brought up the issue of whether, well, first of all, can we regulate these facilities using a conditional use permit? And if we can, does it make sense to, or what's the pros and cons of regulating them through conditional use permits?
I have to preface my comments by saying I'm not a land use attorney, so I do want to make that clear. However, with respect to the issue of permitting these locations, we have to always remember, though I didn't raise this in my initial presentation, this activity is still very much illegal under federal law. Sale, possession, use, distribution, cultivation, all of that. So affirmatively permitting the activity we view as problematic from a legal standpoint.
I see. Okay, and also, I think one of the provisions in the ordinance would require the facilities or the operation to furnish the city with a list of members. Why is that good public policy?
It is a matter of keeping track of the locations and ensuring that, in fact, they are acting not only in accordance with the ordinance, but state law, which requires that only certain classifications of individuals can engage in the activity, specifically qualified patients, those with identification cards as qualified patients, and primary caregivers. So that is to ensure that those individuals meet that criteria.
Okay, so the city would actually go in and check the records to ensure that persons who are actually using marijuana have a legal reason to use it or to be obtaining marijuana. Okay.
Essentially, it's required that such records be maintained on site so that that can be checked.
Mm-hmm. And now the county actually implemented their policy back in 2005. How is this different from the county? Did we were we informed by the county's ordinance? We have spotted geographical boundaries in this region, and one law is going to apply in one place and another apply in another one. Not to say it's a bad thing, we do it with a number of other areas, not just this one, but how is this in just the major areas different or similar to the county? Any particular big issue items?
It's a very lengthy ordinance, and without going through it point by point, we looked at it very carefully and ultimately decided that it was not the appropriate model for the city of Los Angeles. Our position is that to the extent that the county ordinance allows the sale of marijuana through the storefront dispensaries, and again, without getting hung up on the location, but the sale of marijuana is occurring at these locations, and it clearly contemplates that and essentially contemplates a business model. From a legal standpoint, we did not feel that was appropriate for the city of Los Angeles from a legal standpoint in terms of the activity of sale going on at these locations.
Okay, thank you. Well, colleagues, as I mentioned, I support the intent of Proposition 215 and the ensuing state legislation. I do believe that individuals are entitled to receive medical marijuana. However, I'm still concerned about the overconcentration of these facilities in a particular area, and I'm not singling out these types of facilities. Like I mentioned earlier, in land use planning, the overconcentration of any use, I don't think it's good planning. So we need to address that. I would suggest that we come back with that type of language so that we could address that issue. And there's a number of other issues that were raised today that I think we need more clarification on this. And I'll leave it at that for now.
Thank you. Councilman, any questions? No. Well, this is what I'd like to suggest. That we get a report back from the city attorney. Well, let me take a step back. I'd like to have the ordinance made available to the advocates for 1 week. I'd like to put together a meeting in my office with the city attorney, the Los Angeles Police Department, LAPD commissioner, and a representative from the advocates after you've had a chance to look at this ordinance for a week. My intention is not to create an environment of us versus them. We're in this together as one city. So we need to get to an ordinance that's going to work, and not an ordinance that will get caught up in court and delayed and delayed and delayed. So I'd like to offer that to the city family and to the advocates, that we join a meeting in my office in 1 week after you've had a chance to review the ordinance for the next 7 days. Meet in my office and see what we can pound out, see where we can come to agreement, see if there's a place we can get to that's going to work, that deals with the implementation, deals with access, safe access, but keeps within the spirit of the law. Because I do believe folks should have access to medicine. And if this is what cures them or helps them live, then they should have access to it. So that would be my... Right, and I would like to, as my staff suggested, if the advocates can already be prepared with your comments, that you have reviewed the ordinance, and the comments that you have, hopefully the constructive comments, I'm sure they will be, but the issue here is to help the city attorney, help our officers, and help you put together an ordinance that's going to work. And that would be my recommendation and direction to the city family. Are you okay with that, Madam Attorney?
Councilmember, you suggested 1 week?
At least to meet in my office, but to get a report back in 30 days.
30 days, okay, yeah.
Okay. I'm sorry, sir. Anything else on that? Okay, so that would be, are you okay with that, Chief?
Oh, absolutely.
Okay, so in 7 days, in 1 week, we'll meet in my office. We can have the advocates again review, and with comments, come to my office, and we'll have this meeting, and we'll try to put together a strategy and language that's going to work. And I offer our commissioner to join us if he can, so that way we can speak to the actual administration of this process. Yes, if you can speak to my staff before you leave, yes, we will follow up. Okay, so that would be the direction of this committee.
Thank you.
Okay.
Councilman, before we leave item 2, I didn't get a second on Councilman Weezar's request for the report from the planning department on the conditional use process. Was it your intent to include that as part of your instruction?
Yes, thank you very much for the reminder to report on the pros and cons of regulating these facilities with the conditional use permit process, and secondly, to how to develop language and how we could address the overconcentration of these facilities.
Okay, and I'll second that.
Thank you.
Okay, so that'll be the action of this committee for items 2 and 3. Item number 1.
Item 1, Councilman, is a motion, Gruel Rosenthal. It's requesting city attorney to prepare an ordinance to amend requirements relative to anti-graffiti coating and the coating of the exterior of the buildings. And I believe this is a referral to staff, Councilman.
Okay. I don't have any cards on item number 1, so please proceed with your report.
All right, good afternoon, council members. My name is John Beesens from Building and Safety Department, and this is about an ordinance that now requires the first 9 feet of exterior walls of buildings to be maintained with an anti-graffiti finish, resistant finish. And there's 2 ways to accomplish that now. It's either with an impermeable surface design of the first 9 feet, like ceramic tile, or designers can provide for a coating that would be anti-graffiti that would help to make the removal of graffiti easier. And so a group of stakeholders approached Building and Safety, and there were representatives there, architects and people from BOMA, developers, and the Chinatown BID, explaining the challenges of this building code section to Building and Safety and asking if we can do anything about it. Some of the concerns they raised in this stakeholder group was that the impermeable surface was very hard to design and was very limiting in their building design. And the second part was that the coatings were ineffective. The different stakeholders brought up things such as the building's aesthetic appearance is affected by the coatings. The coatings are not maintainable or sustainable with the building. And after graffiti is put on the coatings and later removed, the coatings deteriorate and they just don't last with the building. So there were very many concerns about putting these coatings on the building. So in response, Building and Safety came up with a 3-prong response to this. That one, that the coating previously was not, this is what the new ordinance is about, by the way, so that the owner could now have an option of an affidavit about applying this. So in lieu of applying the coating, they could sign an affidavit that they would remove any graffiti that was put on the buildings in a very timely fashion. And this
for new buildings, correct?
For new buildings, that's correct, for new buildings. And so the affidavit would run with the property so that it would create awareness about graffiti removal and the obligation that people have to remove graffiti. It also strengthens a case when we have enforcement efforts through Building and Safety Code enforcement. If someone is non-responsive to our efforts to enforce anti-graffiti laws, this strengthens the case before the city attorney if necessary. And so those are the 2 things that the changes to the ordinance would bring. And we've also weaved a reciprocal relationship in now with Public Works and the Office of Community Beautification, so that we would refer cases of graffiti removal to them first prior to our enforcement efforts. And if they had any trouble removing the graffiti, they would refer cases back to us, because we have a mechanism to enforce this section. And so, we've added language to our orders to comply also, to direct people to the Office of Community Beautification, and the ordinance is about that, to change those two elements.
Okay. My understanding, though, we also have maintenance and building issues under the housing department, given that they are responsible for the apartments, correct?
Well, this would apply to new buildings.
New buildings.
So a new apartment building, for instance, would have the first 9 feet would have to have this coating or impermeable surface or the affidavit.
So it would behoove us to have the housing department involved in this discussion as well?
Well, I think their buildings, yes, it could always help to get more input.
Okay.
But
go ahead.
I'm sorry. The new buildings already need this coating. So new apartment buildings would be, it's a requirement for new apartment buildings.
Got you.
And this doesn't apply to existing buildings.
I understand.
Okay.
David, did you have something else?
Well, Dave Lara with Building and Safety, all I really wanted to state, in addition to what John had just mentioned, is that we already have the current ordinances in effect to deal with the existing buildings in the form of these complaint-based items that typically code enforcement or the office OCB handles. So I just want to emphasize that we are talking new buildings here only. And these are those buildings that, they submitted to a plan through plan check, they get permitted. This makes it part of that requirement. And it also, in the long term, council member, as I want to stress, is that as we look towards the future, and given the fact that code enforcement resources, are becoming a little more scarce in this day of budget issues, this will at least put more of the onus on the property owners to do the right thing with that, and will not have so much of the need for a code enforcement inspector to go immediately investigate it. This will give them the opportunities, the owners that is, the opportunities to at least move forward with this without us, hitting them with a order to comply.
How much time do you need for a report back, or at least to come back with an ordinance that would include the housing department, of course, with the direction of the city attorney?
Yes, we'd appreciate the involvement of the city attorney in that. If we could probably turn this around in 30 days.
Okay, so you come back in 30 days, working with the city attorney. Let's include the housing department, given their inspection issues as well. And that way we can have a well-rounded discussion. Okay. So we'll report back in 30 days.
Okay, very good.
Okay.
All right, thank you.
Anything else, Roberto, on the agenda?
Public comment, council.
Anybody here for public comment? Seeing none, this meeting is adjourned.